Under the Occupational Safety and Health Act of 1970, the Occupational Safety and Health Administration, or OSHA, is authorized to conduct workplace inspections to determine whether or not employers are complying with standards issued by the agency for safe and healthful workplaces. OSHA also enforces Section 5A.1 of the Act, known as the General Duty Clause, which requires that every working woman and man must be provided with a safe and healthful workplace. Workplace inspections are performed by OSHA compliance safety and health officers who are knowledgeable and experienced in the occupational safety and health field, and who are trained in the OSHA standards and in the recognition of safety and health hazards. Similarly, states with their own occupational safety and health programs conduct inspections using qualified state compliance safety and health officers. Inspections are usually conducted without advance notice. In fact, alerting an employer without proper authorization in advance of an OSHA inspection can bring a fine of up to $1,000 and/or a 6-month jail term. This is true for federal and state OSHA inspectors. There are, however, special circumstances under which OSHA may give notice to the employer, but such a notice will normally be less than 24 hours. These circumstances include the following. First, imminent danger situations which require corrections as soon as possible. Number 2, inspections that must take place after regular business hours or that require special preparation. Number 3, cases where notice is required to assure that the employer and employee representative or other personnel will be present. Fourth, cases where an inspection must be delayed for more than 5 working days when there is good cause. 5, situations in which the OSHA area director determines that advance notice would produce a more thorough or effective inspection. Employers who receive advance notice of an inspection must inform their employee's representative or arrange for OSHA to do so. If an employer refuses to admit an OSHA compliance officer, or if an employer attempts to interfere with the inspection, the Act permits appropriate legal action. Now let's take a look at 5 important parts of OSHA inspection processes. The first part is OSHA inspection priorities. Imminent danger situations are given top priority. An imminent danger is any condition where there is reasonable certainty that a danger exists that can be expected to cause death or serious physical harm immediately or before the danger can be eliminated through normal enforcement procedures. If an imminent danger situation is found, the compliance officer will ask the employer to voluntarily abate the hazard and to remove endangered employees from exposure. Should the employer fail to do this, OSHA, through the regional solicitor, may apply to the federal district court for an injunction prohibiting further work as long as the unsafe condition exists. The second priority is given to investigation of fatalities and accidents resulting in hospitalization of 3 or more employees. Such catastrophes must be reported to OSHA by an employer within 48 hours. Third priority is given to formal employee complaints of alleged violations of standards or of unsafe or unhealthful working conditions. Programmed inspections are aimed at specific high-hazard industries, occupations or health substances, or other industries identified in OSHA's current inspection procedures. Industries are selected for inspection on the basis of such factors as the injury incident rates, previous citation history, employee exposure to toxic substances, or random selection. Special emphasis programs may also be developed and may be regional or national in scope, depending upon the distribution of the workplaces involved. Manufacturing industries may be inspected when their lost workday injury rates are at or above the Bureau of Labor Statistics' national rate for manufacturing. The fifth priority is follow-up inspections to determine if previously cited violations have been corrected. If an employer has failed to abate a violation, the compliance officer informs the employer that he or she is subject to failure to abate alleged violations and propose additional daily penalties while such failure to abate or violation continues. Preparing for the inspection, the compliance officer will become familiar with as many relevant facts as possible about the workplace, such as the inspection history of the establishment, the nature of the business, and the particular standards that might apply. When the OSHA compliance officer arrives at the establishment, he or she displays official credentials and asks to meet with the appropriate employer representative. Employers should always ask to see the compliance officer's credentials. An OSHA federal or state compliance officer carries official credentials that can be verified by calling the nearest federal or state OSHA office. Compliance officers may not collect a penalty at the time of inspection or promote the sale of a product or service at any time. Anyone who attempts to do so is bogus, and the FBI or local law enforcement officials should be contacted immediately. In the opening conference, the compliance officer explains how the establishment was selected and determines whether it will be subject to a comprehensive safety inspection. The compliance officer explains the purpose of the visit, the scope of the inspection, and the standards that apply. The employer will be given a copy of applicable safety and health standards, as well as any copy of an employee complaint that may be involved. However, the employee's name will be deleted if the employee has requested anonymity. The employer is asked to select an employer representative to accompany the compliance officer during the inspection. An authorized employee representative also was given an opportunity to attend the opening conference and to accompany the compliance officer during the inspection. The Act does not require that there be an employee representative for each inspection. However, the compliance officer must consult with a reasonable number of employees concerning safety and health matters when there is no employee representative. During the inspection process, the compliance officer observes safety and health conditions and practices, consults with employees privately, if necessary, takes photos and instrument readings, examines records, collects air samples, measures noise levels, surveys existing engineering controls, and monitors employee exposure to toxic fumes, gases, and dusts. Trade secrets observed by the compliance officer will be kept confidential. OSHA places special importance on posting and record keeping. The compliance officer will inspect records of deaths, injuries, and illnesses, which the employer is required to keep. Where records of employee exposure to toxic substances and harmful physical agents have been required, they also are examined for compliance with the record-keeping requirements. Also included is the Hazard Communication Standard. Under this rule, employers must establish a written, comprehensive hazard communication program that includes provision for container labeling, material safety data sheets, and an employee training program. Other required records of employee training may also be subject to inspection. Some apparent violations detected by the compliance officer can be corrected immediately. When they are corrected on the spot, the compliance officer records such corrections to help in judging the employer's good faith in compliance. Even though corrected, the apparent violations still serve as the basis for a citation and, if appropriate, a notice of proposed penalty. An inspection tour may cover part or all of an establishment, even if the inspection resulted from a specific complaint, fatality, or catastrophe. After the inspection tour, a closing conference is held with the compliance officer, the employer, and the employee representative. This is the time for free discussion of problems and needs, a time for frank questions and answers. The compliance officer will give the employer a copy of employer rights and responsibilities following an OSHA inspection, and then briefly will discuss the information in the booklet and answer any questions. After the compliance officer reports findings, the area director determines if citations will be issued and if penalties will be proposed. Citations inform the employer and employees of regulations and standards alleged to have been violated and of the proposed length of time set for their abatement. The employer will receive citations and notices of proposed penalties by certified mail. The employer must post a copy of each citation at or near the place of violation occurred for 3 days or until the violation is abated, whichever is longer. The objective of the OSHA law is to provide a safe and healthful working environment for all employees.